Hello, my name is Kristina Crump. I'm an attorney. I practice consumer bankruptcy law in Kansas and Western District of Missouri. This is my partner, Chris Coons.
Hi, I'm also a consumer bankruptcy practitioner, and most of my practice is in Kansas and some is in the Western District of Missouri. And I've been doing this for a little bit over 20 years. And together we have a firm, Coons and Crump, and we only do consumer bankruptcy work, and we only represent debtors. So we don't do any creditors work.
We do Chapter 7s, Chapter 13s.
That's right. No Chapter 11, no Chapter 12.
Correct.
Right.
Yep.
We farm all that out, I suppose, especially those Chapter 12. Some of you will get that joke. Anyway.
So today we're going to talk about what does it take to become a consumer bankruptcy attorney in Kansas right now at the end of 2022. Beginning of 2023.
Well, and let's preface this by saying most of the time when you see a CLE and it talks about getting into a certain sector of the profession, it's often just a big scare session where what you get out of it is, I should probably not do this, it's a bad idea. And if you're talking about something like bankruptcy and you're talking about dabbling, and you're going to be a dabbler, that's probably true. You probably shouldn't do it. It's probably a bad idea. It's not a profession well suited to people that are dabbling. There certainly are plenty of cases that will get filed and go through easily. But the problem is issue spotting. It's spotting the issues.
And there's thousands of them.
And there's thousands of issues. But I think what we're gonna do is we're gonna start what basic office setup and things like that. Do we want to cover that?
Sure,
briefly?
Why not?
Okay. Kristina, we have data management software?
We do. Data management software.
Calendaring system?
Calendaring system. We're pretty sophisticated, actually.
Email management system?
Email management system.
Remote work?
Yes.
Even
pre-pandemic.
Even pre-pandemic, we were remote. I definitely remember that. What about bankruptcy software?
Yes, and that can be expensive, and that's probably a must. I think the forms are available on at the court's website. However, in order to file those forms, you probably want to have some kind of software in place. And we're talking $5,000 to $10,000 a year commitment.
Well, for us.
For us,
I think for a smaller practitioner, quite a bit less.
Quite a bit less.
In fact, there are certain software programs you can get that you can pay by the petition. So you can pay them by the petition as you use them. We don't do that. We actually file enough cases that would not be really a good idea for us. So we pay for an entire package. And a set number of licenses so us and the staff can all have access to the software. Do the numbers change regularly in bankruptcy? Does the means test change?
Yes, they do.
If I said
numbers change every 6 months at least.
I thought it was every 3 months. I'd have to check. I'm not positive. They change, and here's why we don't really have an absolute idea, because it does it automatically for us.
Well, the software.
The software,
does.
right? There are notices, but our software package automatically updates, so I don't have to go and check the means test numbers. Now I try to track when they're going up or down, because it will have an effect on cases I have coming in the door. Some of them may need to be filed sooner, or some of them may benefit by being filed later. So. That matters, but the big thing is you probably need a professional software package in order to make this work. What else? What do you have to file? What about CMECF?
Well, you have to apply for PACER account. You have to have some setups there.
What's PACER? That's the public access system?
Correct.
Online?
Correct.
Okay. And are bankruptcy cases all online at this point?
Yes, they are.
And they have been.
And they
for
have
long.
to.
Yeah.
They have to be online. Like, you cannot walk into the courthouse and file something as an attorney.
But an attorney can't.
On paper.
I
think a pro se person.
A pro se person, if somebody doesn't have counsel, they can probably walk into the clerk's office and hand file a document. But if you're a lawyer, that's not going to fly. You need CMECF privileges, which are electronic filing privileges. So if you want to file bankruptcy cases, you have to go through this training on how to operate the CM-ECF system. And so for us, we all have CM-ECF training, and we have staff people that have CM-ECF training. For us, the staff are better at CM-ECF than we are. There are all these codes. When you file a document, you have to code the document as the document gets filed. Now, a lot of the bankruptcy software has some type of what we call one-touch filing option.
Correct.
Oh.
Yes, and a lot of them are user-friendly. Now, we're not endorsing one over the other.
No.
Not doing that.
No,
But a lot of them really give you the basics, basically have the updated numbers, the ability to input the data in a user-friendly format, which will then be filed electronically through the CM-ECF system with the federal courthouse.
How quickly do the notices come out on when you file a bankruptcy case?
Well, some immediately, depending on who signs up for electronic access, and the rest by mail.
And you'll have a combination thereof too. Like we get electronic notices and we get mail notices. So you have to track these notices. So minimally, you're going to have a 341 hearing. If it's a Chapter 7 case, minimally you're going to have like a 341 hearing, and then you're going to have a date where the debtor has to provide some additional information.
You definitely need to have a really good calendaring system. You will get electronic notices from the court, and lots of them. I mean, there's at least 10, 15 per case filed, and some of them are pretty important in terms of keeping track of the dates. As a matter of fact, a lot of things in bankruptcy are really keeping track of dates and being on top and not late to the table.
Right.
When it comes to the practice. So software system to prepare petitions, and then calendaring system is a must.
Email system.
Email systems.
Right. And of course, it goes without saying, we have a phone system to basically handle all the traffic. Because of the size of the office here, we have additional staff. So each attorney has a couple of paralegals that they answer to, and receptionist, and it's very helpful to have a bookkeeper, because there are going to be a whole bunch of financial transactions going on in the office when you're getting paid, if you're doing Chapter 13 work in particular. This is not so big in Chapter 7, but if you're doing Chapter 13 work, it's very likely that you're being paid fees through the Chapter 13 trustee, and you're going to want to be able to track those fees and also to be able to track your billing, because you're not going to get paid anything where the court has not approved the fee. And for the fees that are done post-petition, the vast majority of those fees are going to roll through the case, and I don't want to be the person tracking all that, so we have somebody that helps us do that. What about credit counseling?
Oh yes, there's 2 credit counseling classes folks have to do when they file a case, one before, one after. There are hundreds probably of companies out there that are able to provide that credit counseling class, including some of the local nonprofits. It depends. It's a requirement, something that must be done. Just depends on how you want to pursue it. You can send your clients with a list. Hey, here you go. Do a credit counseling class. You can send them probably to a particular one that you like, so that you get certificates right after they're done.
Right.
So there are different options, but that's also something that has to be set up and tracked, unfortunately. Lots of things in bankruptcy, I think, or management, is the tracking of documents, financial documents, and certificates, and other requirements, tax returns.
And we don't endorse a vendor, but we have a vendor.
Correct.
So we have somebody that we use to do the pre-filing credit counseling, and then the
we found it
post-filing.
easy for us to just work with one provider, so that way, if we have any questions, concerns, in theory, we can reach out and
Well, we're not going to name them, but
helpful,
they're good. No, we don't have any problem.
Yeah.
And they're
We
not.
don't reach out often, so that's
No.
good. That's good news.
They're not expensive. We include their fees in our fees. So we don't have to. We try to reduce the number of touches the debtor has to do on these kinds of things so that it gets done. But you got to have that stuff set up in order for it to work. So on the administrative side, because of the size of what we're doing, we have staff. But there are plenty of small practitioners who really don't have staff. And I would say consumer bankruptcy is 60% or more of what they do. And they do it all themselves. And there's obviously there's more of a limit to what you can cover when you're doing all the administrative work yourself. But it's certainly possible to do it. But it has to become, I think, really a focus of your practice.
Right, right. Well, I want to talk about this idea that we as bankruptcy attorneys, I don't know, fill in the paperwork.
Yeah. Okay. This is kind of a running.
Submit some forms.
Right. It's kind of a running joke. And
how easy it is.
It's yeah. I never lose any sleep at night. I never wake up with bad dreams from my clients. These are all lies. Nobody ever calls up here and is upset. Never, right? And I know the answers to all these questions about bankruptcy.
And most importantly, the answers to all the questions are a Google away.
Oh.
So it's super easy to find the answer to that.
You've all heard of Google MD, but I refer to it as Google JD. And Google JD is the enemy. In a way, because bankruptcy is...
But not only for the public, but for an attorney.
Oh, for attorneys too. Oh, no, for us too.
Yeah.
Google JD does not take into account that bankruptcy of almost all the areas that you can think of that might involve federal practice. Bankruptcy is 50 laboratories because the state property law in each state is going to be taken into account at the federal bankruptcy court level. And oftentimes, under, if I remember correctly, the Erie Doctrine, who can believe I'm even mentioning this, the federal bankruptcy judge is going to have to guess or extrapolate what the Supreme Court in Kansas would have ruled in a theoretical property law case that would have made its way up. Only the ruling is going to apply to an individual bankruptcy case. And so they've got to give Kansas property law its due course in bankruptcy cases. And this is going to apply in any other state. And so debtors and lawyers will go online and type in a question about bankruptcy, and they'll get an answer, and the answer has nothing to do with where they live or what's going to happen in their case or what is going to go on. In fact, it's going to be completely different. I think what you're getting at, though, is that administratively, what we do sometimes, it looks like administrative work, like we're just filling out documents. But substantively, what we're really doing is issue spotting. And if I were to say the biggest thing about being, or most important thing I would say about being a bankruptcy attorney, a consumer attorney, is learning to spot issues that are going to have an impact on your client's case and that your client needs to be advised of. And I'm also going to say that despite the issues, your client may do exactly the same. Well, they might do the same thing or they might do the opposite, but that decision may have already been made for them because of how bad their circumstances are.
How important is issue spotting in especially Chapter 7s? Aren't Chapter 7 trustees paid based on what they recovered?
Sure. And we are very fortunate in Kansas. We currently have 4 active Chapter 7 trustees with a ton of experience, and they're all very nice people. And when you have questions about your cases, you can pick up the phone and call them, but they can't give you legal advice. And they can't tell you what to do.
Yeah, but their job is also to...
Their job is to collect money for the estate.
Money.
And they do it,
and they do it often.
And they're good at it. And these are really experienced people. And they're very good at it. But sometimes there's money where you think there's no money. And this becomes...
Even as an experienced practitioner,
yeah,
you
absolutely.
think there is no money, and there is money.
And there's money. Yeah, and there's money. So you do have all kinds of cases where what you're trying to figure out is what is the threshold at which the bankruptcy trustee is going to go into action and attempt to liquidate assets. Chapter 7 cases are called liquidation cases, and a lot of the issues you're trying to spot are what assets are available for the Chapter 7 trustee. That's one big issue. And when we think of assets, I'm not just talking personal property. I'm talking transactions that can be unwound. So let's imagine that my client gave a car to his brother, and it was 8 months ago, and let's say it's a $3,000 car, and the brother was on hard times. Can the bankruptcy trustee unwind that transaction? Well, if there was no value given, yeah, absolutely. One of my favorite cases, and this is an actual Kansas case, a landlord was going to file bankruptcy, and he went to one of the tenants in his properties. He had I can't remember, he had 8 or 10 properties, and I think they were all right next to each other. They were like a bunch of duplexes next to each other. And he told one of the tenants that they were friends with, don't pay rent, I'm going to file bankruptcy. If you pay it to me, it's not going to go anywhere. I don't care. Don't worry about it. And so the guy stopped paying rent. And the landlord files the bankruptcy, and the bankruptcy trustee comes in and says, I want a ledger of everybody who owes you rent or who has not paid rent. And if you received rent, I want to know what happened to that. And so it comes out that the friend who has not paid rent, I want to say for like 6 months, and the bankruptcy trustee sues the friend essentially on the theory that they got a benefit for which they did not pay, even though they were instructed not to pay, that there was this benefit they received, and that they had to pay the benefit over to the bankruptcy estate. If you're looking at issue spotting and you're trying to look at transfers, you're looking at payments to friends and relatives, you're looking at money owed that you don't necessarily think about, you're looking about potential inheritances. So if somebody comes in and says, my grandparent is on death's door and I want to do a Chapter 7 today, well, and I ask as the attorney, hey, is there an inheritance coming? Oh, yeah, $1 million. I'm going to run from that case probably, because that case is going to scare me, because if the grandparent dies within 6 months of the case being filed, and it's an actual inheritance.
In a Chapter 7.
In a Chapter 7, yeah. It's like inheritance, devise, or bequest, but it will come into the estate, even though the death occurs after the case is filed. What if it's a trust? Well, then it may not come in at all. It probably will be kept out of the estate. And there are certain other life insurances usually kept out of the estate under those circumstances. But
would it be fair to say, though, that a lot of these questions, when asked, I guess, in a format, the one that the bankruptcy forms use, are probably not answered correctly by majority of your clients?
So this is the domestic support obligation idea, or what's a bequest, devise, or inheritance idea, or any number of things that we as lawyers think about in our own practices. The language that we use is often unique to our own practice. And when you use that language with the average citizen, they kind of gloss over it in their brains. Their brain assigns a meaning to those words that may be completely different than the meaning you intended. And I do think
or the code intended.
Or the code intended, or the case law indicates.
Sure.
But I do think that the forms themselves when you have debtors fill out a form, that's a starting point. So I, although this is not what everybody else does, I tend to go over all the questions personally with my clients and maybe get a little bit more detailed information about what they have. Valuations are another issue. I mean, we talk about what stuff is worth, and your clients, to be blunt, are not to be trusted. Your clients think that the stuff they like is gold and the stuff they don't like is not worth anything.
It's not worth anything, yeah.
And oftentimes it's the opposite. The stuff they think is not worth anything is actually worth quite a bit, and the stuff they think is gold is junk. You know, I mean, I've had people come in with comic book collections, and you know, here's 10,000 comic books, and you ask the client, "What's that worth?" And the client goes, "20 grand. It's worth 20 grand." Now, I've been fortunate enough to have an expert, a comic book expert, who can look at these things and tell me what they're worth. And I remember one of my clients telling me this, and the expert said, "Yeah, there's $1,000 of stuff there, and the rest of it I would not even buy. Like, if I bought it, I'd buy it by the pound, and it'd be a quarter a pound." And he's not joking. It's just not worth anything. Does the client have 20 grand invested in it? Sure, absolutely. He probably paid 20 grand for the stuff. But today, it's just not worth anything. Mechanics tools are another one of those issues. People that come in with boats, motorcycles, jet skis, all this other stuff, and guns. Yeah,
Any kind of collections. Any kind of collections.
Yeah, and people will tell you their guns are not worth much in some cases, and then they will overvalue them in other cases. And then there's getting them to disclose property. So how you ask questions matters. And so if you ask somebody if they have firearms, I will get this common answer, which is not in my name. And I will have to explain to people that you don't register firearms in Kansas. There is no list with their name on it. Some people still do get concealed carry permits because there's reciprocity amongst other states, but you don't even have to have that in Kansas now. So if they own a gun, and it's when you own property in bankruptcy, it's equitable or legal title. It does not matter. If you have either, you've got to list that property and what your interest is in it. And so you really got to quiz the clients. You really got to go over the property. You've got to go over the transaction histories. You got to take a look at things to find out what kind of substantive issues do I have. And then you got to figure out, can I overcome the substantive issues? How can I overcome them? For instance, can I make a deal with the Chapter 7 trustee to avoid having them seize all the stuff?
Or do I absolutely have to be in Chapter 13?
Well, yeah,
right?
yeah. Well, yeah, there are going to be times where you're going to have a client come in who wants a 7, and they're going to need a 13. And so a 13 is called a wage earner's bankruptcy. There is no liquidating trustee. There's a trustee that is going to essentially supervise a plan that the debtor is going to propose. And they're going to make a payment, and it's a periodic payment, although what that means is debatable, but let's assume it's monthly because that makes it easy on all of us. And your client's going to make a monthly payment, often by wage withholding order, and often it is going to pay a vehicle, missed house payments.
I have a question. Now, as an attorney, especially somebody who's trying to get into bankruptcy, can you choose just to file one type of bankruptcy or talk only about, say, Chapter 7s?
Yeah, that's malpractice. I mean, I just want to say that right out the gate. If the only tool in your toolbox is a hammer, everything damn looks like a nail, okay? And so if the only thing you have in your toolbox is Chapter 7, that's it. That's what you're going to hit every debtor with. You've got to not do that. You have to understand both 7 and 13, and you have to have a passing knowledge of 11 and 12. Passing, I say.
Sure.
But
at least know they exist.
You got to know they exist, and you got to know some very basic things about them. But when you, as debtor's counsel, sign that case, you are signing a statement that says, I explained both Chapter 7 and Chapter 13 and 11 and 12 to my clients. The reality is you're probably going to have a pretty brief explanation of 11, which is usually for big corporations,
Right.
and 12 for farmers.
Well, how often, I get these, I guess, questions quite often where a client says, I know what chapter I want to file, and it is Chapter 7.
Absolutely.
Yeah.
You bet.
Still have to go through the options. Still have to discuss both options.
Oh, you're required to.
Yes.
You must go through both options. Debtors ultimately decide what kind of case they're going to file. And I think if you look at the rules of ethics, that is their decision. They get to decide what kind of case they're going to file. You get to decide whether you're going to represent them in that case. That is your decision. So if a debtor says, I want to do a 7 no matter what, I'm filing Chapter 7, you can't talk me out of it. Your response, if you don't want to, if you think they shouldn't do a 7 or you think they're not eligible for 7, which by the way, they may not be eligible for a 7 for a whole host of reasons. But your option at that point is to say, I wish you the best of luck. And you'll have to go somewhere else to do that. I cannot do that for you. And what if they change their mind at that point and go, well, I'll do a 13 then. I think you still should refuse service. Why do I think that? Because there have been cases where debtors have argued they were coerced into the course of action they took because their lawyer refused to file a 7 for them. And they were
Or
forced
13.
into the, or 13, but they were forced into this option and they stayed with the same attorney. And then later when things inevitably go bad, which they do, I mean, you know, clients that talk like this usually are not great clients. But when things go bad, they then turn and blame the attorney and say, well, the lawyer coerced me into this course of action.
How often do you see people qualify for both 7 or 13 and really getting maybe similar outcomes out of that?
All the time.
Yeah.
All the time. I mean, I think that I always say that Chapter 13 is underrated in terms of the outcomes. That the outcomes in 13 are often quite a bit better than they are in 7 for a whole host of reasons. One, you often have a lower payback on the property. So if you have to pay back money for the value of non-exempt property, you're often getting a slightly better deal in Chapter 13 to pay it back. But most importantly, you're often getting 3 to 5 years to pay it back.
Right.
But it's also taking care of priority creditors like income taxes that you cannot really take care of in Chapter 7 under the same circumstances. And also you have, and arguably most importantly, a right of dismissal. So if things go south and you don't like the way the case is going, you have the option of getting out. And in Chapter 7, do you have an option of getting out?
I don't think so. I'm not aware of one.
Not automatically. You can file a motion.
Sure.
You can file a motion, but that is a steep hill to climb. And so if you're looking at getting into this kind of practice, there are some things that you've got to kind of wrap your head around about what bankruptcy can do for your clients. I think that the local bar, the local bankruptcy bar, holds a lot of CLEs. The attorneys are friendly, inviting. They're looking for more attorneys to come in. I think they all run very, very different kinds of practices. So a lot of them are, I would call them boutique, small shop practices. I would call us a boutique practice. I mean, there's only four attorneys in the office, and yet we're one of the larger bankruptcy firms in Kansas, which is kind of silly. But that's that's just a representation of how much business. Yeah, that's how much business there is out there right now. Marketing.
Sure, let's talk about that.
Okay.
How do you get clients? So you decided you're going to start your law firm, you want to do some bankruptcy cases.
Right.
Maybe you got your first client because, I don't know, you're in a small town and somebody needed a bankruptcy and they called your office. But what if you decide that you love this practice
Right.
and you want to build on it?
Move out of the small town. That's my first advice.
What would you do?
Move from the small town.
No.
Okay, all right. Okay. Right now, I would say that you could probably run a bankruptcy practice from a small town in Kansas and still make it the majority or bulk of your practice, because currently so much of what we do is remote.
Yeah, thanks COVID, right?
Yeah, thanks COVID. So when COVID came along, a lot of the bankruptcy practice went to Zoom and went to the phone. So 341 hearings, that's a mandatory hearing clients appear at after the case is filed. Currently, those are being done by phone. Now, I appear in person in Topeka.
I appear in person in Kansas City.
Right, this is for our hearings in front of the judge. So, and I like doing that. I think you like
sure,
doing
I
it
do
too.
too.
Right, yeah.
But your daily appearances with your clients at 341 hearings, those are by phone now.
It's by
So
phone. But
that's-
even a lot of my meetings with
That
clients,
frees up a lot of time.
yeah, I meet with my clients on Zoom. I do a lot of Zoom meetings. I get documents ahead of time. I talk to clients on the phone a couple of times. Then I set a Zoom meeting. And I like to draft my cases personally. I think
I do too.
You do too. So we like to draft our own cases. We don't, some offices, a para drafts the
Nothing
cases.
wrong with that?
Nothing wrong. That's not casting aspersions. Yeah.
Nope.
And some attorneys really like doing it that way. We don't. That's just us. That's just a personal thing for us. But you can do those meetings on Zoom, which means in terms of access to justice, if your clients are out in like Goodland, you can still represent them. And they don't have to drive into court. So, I mean, when we talk about filing from a small town,
So you can
And
have an
marketing.
office in the middle of
Right.
nowhere
But let's-
and potentially have clients, but how do you get
yeah,
those
yeah.
clients?
So if you're in a small town, I think the only way you're going to get clients, because you're going to have to go outside of that town. I think the only way you're going to be able to get clients is arguably Google AdWords.
Or advertising.
Or well, it's advertising, but I mean, like when we talk about advertising online, and you talk about the different forums that you can advertise in, and the big ones are theoretically Bing and Google.
And Facebook. Well, they are ranked.
Yeah, sure. Yeah, I mean, look, they're it's all online media.
Yeah.
And so there's essentially online search, and then there's maybe online spray, and Facebook and things like that, where you're going to have banner ads. Those are not really directed at people.
Got to be careful with those, though, because there might be some rules
That is correct.
prohibiting you from doing
That
certain
is
things
correct.
on
That's
the
right.
internet.
That's right.
So,
When you get into bankruptcy and you're doing any kind of credit management or debt management, advertisers on the internet will put you into a category that essentially will say you're limited in the types of ads that you can run, and they really do watch you. It's a real thing. They kind of watch you. So that's one way of bringing in business, though, is that you're actually going to go and do online marketing, and you're going to pay. And there are different ways to pay. You can pay by the click, means if somebody clicks on your ad and goes to your website.
pay by phone call nowadays.
You can pay by
Yeah.
phone call. That's a whole nother thing that you can do. And
Pay for displays.
pay for display. That's mostly
Show
Facebook.
everywhere.
Right. That's mostly Facebook. And you can set all of these things geographically. In some cases, you can set them by income level. There are all kinds of algorithms that can help you pick out a market. There are a bunch of things you can't do when you define your markets. You can't exclude people in certain ways, but you can get into more detail with that. But that's all paid marketing. The phone books are almost non-existent. In addition to the kind of online advertising that you're all probably very familiar with when we talk about display advertising and arguably Google AdWords or paid search advertising. There are some other more traditional sources of advertising. We do not use them, but you'll see people using billboards. PI attorneys will use billboards. I've known some bankruptcy attorneys that have done that. I've seen some bankruptcy attorneys do local street display advertising. We don't currently do direct mail. I think in Kansas there is a way to look at doing some direct mail advertising, but we're not currently doing any of that. But I do think some of that's a possibility. One of the things I often kind of laugh about is that we would have clients come in our Johnson County office, and they would have received direct mail from 3 other attorneys, but not us, and not gone to see any of those lawyers and come to see us.
Well, they Googled.
They Googled, yeah.
Googled.
They Googled, but the direct mail put them in the direction of thinking, hey, maybe I need to find a bankruptcy attorney. I would also say that in terms of online marketing, that where you're not paying for any of the advertising, they're simply doing organic search. So you're going to put up a website, you're going to publish articles.
Yeah, but it's not free.
Oh no.
It's
oh no. Oh no. Oh no.
Oh
No. Yeah. You're arguably
it's more expensive.
Arguably, you're going to pay the most for this.
Yeah.
Because it is going to consume your time. There are agencies you can get to help you. There are a number of agencies that are out there. There are experts you can get. It's all going to cost money. Every bit of it. And you've got to decide, how much business am I trying to get? How competitive do I want to be? Am I going to want to run an office where I'm bringing in 3 to 5 cases a month? Or am I trying to get 10 to 15 cases a month? Or am I searching for something 35 cases and above? I would say there's probably only one firm in the state that's doing the 35 cases and above, and that's probably us. And I would say there's maybe a couple of firms that are in the 10 to 15 range. There's a few.
Maybe a little more. Sure.
4 or 5 maybe. Yeah. But hardly anything above that. And then I would say there's a whole host of practitioners that are probably in the 3 to 5 range. And that's probably doable. I mean, that's probably a pretty doable thing. Kansas bankruptcy practice is in consumer practice is about half Chapter 13 and about half Chapter 7. I would tell you that every lawyer that does this has their own idea of how it should be done.
Oh, sure.
But they're all willing to talk about it. And I mentioned earlier that you could get a lot of free CLE because the local bankruptcy bars give out CLEs. So there's a lot of lunchtime CLEs. Some of them are on Zoom. And for just joining one of these local area bankruptcy associations, you can get a lot of free CLE. You can be introduced to the people who appear in the court regularly, and you can kind of learn who the players are, both on the debtors and the creditors side, and you can hear the judges who will frequently speak. I would also say that you can go to court, and you can sit in on dockets, and you can even call in and listen to dockets.
Yeah, no, it's very convenient.
It's very convenient. I don't think you get as much calling in because you can't actually, there's a lot of communications you're missing when people are doing in-person hearings. But you can actually sit down and kind of listen to what is going on in the cases. The other thing is the cases themselves are on Pacer. If I want to know how another bankruptcy attorney did an issue, I can go on Pacer if I heard about the case. I can look the case up. I can read the motions. I can look at the petition. I can look at, if there's an adversarial proceeding, I can look at the adversary, and I can see how did this person handle all these issues. If I'm worried about how much my fees are or whether I'm charging the going rate, I can look at their fees. There's so much information that you can get that will help you figure out how you want to run your bankruptcy practice and what kind of bankruptcy practice you want to run. I think it takes a number of years to get good at issue spotting, and you never stop, like any other area of the law, you never stop learning. You never stop. And I tell clients all the time, you think you know until you don't know.
Sure.
You can do something, and we all know this, you can do something one way 20 times, it works every time, and it doesn't work because you're right, it works because nobody's looking, nobody's paying attention. And the problem is you begin to think, I know what I'm doing, I understand this issue. And then the 21st time the judge goes, I don't like the way you're doing that. And sua sponte, the court sometimes will sua sponte tell you, please don't do things this way. And the courts are reading what you're submitting. Mm-hmm. It's not being submitted blindly, but they'll look at it and eventually they might go, yeah, would you stop that? Or would you do this differently? And at that point you suddenly realize, no, I got to go back and rethink this. I got to go back and rethink what it is I've been doing. Putting together a bankruptcy practice is challenging. I personally find the practice rewarding. I think like every other lawyer in the universe, I wish I got paid more. I should be paid more, Kristina.
No, we all should be paid more.
But me in particular. But it's definitely an enjoyable area of practice where you can give a tremendous benefit to your clients.
Definitely help people.
Yeah.
And it's almost immediate. Well, it is immediate.
It's immediate.
Once you file.
Once you file, that help is pretty immediate, you know. Mm-hmm. What about tracking documents?
Sure, let's talk about
that. So how much paperwork do we often have to provide to the bankruptcy trustees?
Well, lots of paperwork, IDs, social security cards, usually at least 2 years worth of taxes, pay stubs, sometimes 60 days, sometimes 6 months, sometimes bank statements depending on the circumstances, sometimes other financial documents if there are assets, especially non-exempt assets. And all of that, of course, needs to be tracked, needs to be scanned in. Most of the trustee want these things uploaded through their systems. So there are a couple systems, other systems to learn in terms of how to upload documents there. I think all the trustees are really good about providing that information, though, so it's pretty straightforward and relatively user-friendly.
What about being paperless?
Well, we are paperless. I don't know about other offices.
Do you think if we weren't paperless, things would run as smooth as they do?
Oh, no, we would drown in papers. I can't even imagine having paper files everywhere. I can't imagine that.
How do clients sign cases?
Right now, electronically. Yeah. Now, there are different systems that you can use for that. Some paid, some maybe part of your software. I'm not sure there's any free software to use, probably not. So that's another expense. But you can also sign it in person if need be, or that's probably a preferred method for some, is for the clients to come in and sign the paperwork in person. And that used to be the norm until 2020.
Yeah, until COVID. Mm-hmm. Yeah, we started doing everything remote, even electronic signatures.
Really, like the technology, even in bankruptcy world, really, I don't know.
I don't know if it's so much it evolved as we began to make use of all these other technologies that were out there.
We got caught with times.
Right, but now it's pattern and practice with what we're doing.
Yeah, now you can think of like how are we doing it beforehand. Well, even think about access to attorneys, because in the past, people who lived in Western Kansas would have to drive 5 hours to potentially meet with an attorney somewhere like in Wichita.
Right.
And now it's a Zoom call away or phone call away.
What about where cases have to be filed?
I'll let you talk about that.
Okay, all right, I'll talk about that. So if you live in Butler County or you live in Sedgwick County, you must file your bankruptcy case in the Wichita Bankruptcy Court. That's right, the Wichita Division. Okay, so you must file there. If you live in Shawnee County, you must file in Topeka. If you live in Wyandotte or Johnson County, you must file in Kansas City. If you live anywhere else, you get to choose where to file. So this means that some attorneys who are in Kansas City can market out in western Kansas
And
still file in Kansas City. Right, they can still file in a location that they're comfortable with. We currently file in all 3 locations, and we're currently comfortable in all 3 locations, and we actually have office space in all 3 locations. So for us, it probably, when they implemented that rule, it didn't make any difference. But for a lot of attorneys, it made somewhat of a difference because...
But that's also something to watch out for, to plan for, because the 341 hearings that you have to attend might be at the same time as court hearings in another location. So you really need to know your limits in terms of organization and how you're going to manage your calendar.
Yeah, so all 3 bankruptcy courts, it's one of the issues, all 3 bankruptcy courts kind of run their own schedules.
And sometimes they
overlap.
Sometimes
they overlap. So if you're filing bankruptcies in multiple locations,
you have to watch out for that.
You have to watch out for that. And sometimes you'll need help. You'll have to, like for us, we have other attorneys in the office to help us out. But in some offices, they've got to ask somebody to step in and cover hearings. But that is certainly one of the issues you have to contemplate when you're thinking about doing this. Right. So I mean, I tend to think of this as in terms of how you run an office, a bankruptcy office. There are a couple of factors that I tend to look at. I look at the administrative side of things. I look at the substantive practice of law as a different issue. And then I look at the business aspect of this, which is getting back to the marketing. And I tend to see those things as they're all, for me, very fundamentally different issues.
Sure.
And you kind of have to decide, well, what kind of an office am I looking to run? What kind of an office size-wise? And also you have to look at what will the market bear where I am. Because if you are in a small town and you say, I want to do 30 cases a month, that's probably not likely. That's probably not too likely to happen. So it's difficult to bring that kind of business into a small place.
Well, like in any consumer practices, you have to be really good at all 3 because you are not really counting on hitting that home run once every 10 years that bring you millions of dollars, because they don't exist.
There's no home runs in bankruptcy.
So you have to be very consistent and diligent about, what do you call it? Hitting singles?
Singles all day long. Singles all day long, baby. First, second, third home. First, second, third home. That is the gist of being a bankruptcy practitioner. It is consistency. And you want to have consistency in the quality of service that you provide. I mean, look, we don't kid ourselves. We have to do customer service here.
Absolutely.
It is an absolute requirement, you know. And we take that to heart. It means something to us. And I think that for most practitioners, if you're going to do bankruptcy work, you need to understand that that's going to be part of it.
Sure.
Oh,
a big part of it.
Yeah, getting back real briefly to the marketing, I want to talk about real quickly about some things that I think people shouldn't do.
Oh, yes.
Yeah, I almost forgot about that.
Yeah, I almost forgot about that.
No.
Important things.
Let's imagine that you decide to become a bankruptcy practitioner and you find some large national firm.
Or imagine somebody reaches out to you.
They reach out to you and they say, we are a large national firm and we would like to make you a partner. And we will funnel you business and you will get paid a sum of money, or we'll provide support. You'll get staff support from us. We'll provide support and we will help you with your marketing. In fact, we'll handle your marketing. You won't have to do any marketing. And you don't have to pay anything to us for doing the marketing. When the clients pay the money, they'll pay the money to us. We will pay you a fee to essentially manage the case as the attorney on site. You'll file the case, you'll conduct the 341 hearing, and then it'll march on. If you're ever tempted to do these things, please think seriously about it. There are case law is out there telling you not to do this, that it's probably a very bad idea. First off, these kinds of businesses, you're never really a partner. You're not a law partner. You have no vote. You don't have any equity in the business. You're not getting a share of the profits. That's not usually how these things work. Usually they're paying you 20 cents on the dollar, 30 cents on the dollar for the work that you're providing. And usually their support staff are incompetent because they're not in Kansas. The support staff are somewhere else, and they just don't understand how things work where you are in the jurisdiction you're in. And so you end up doing all the work again yourself. And oftentimes, by the time the clients get to you, the clients have been waiting for months because the person you're dealing with, the large law firm, is demanding a large amount of money up front to get a case filed, which in many cases is not necessary in Kansas. It is in some, but not in all of them. When you start thinking about these things, though, they're just terrible ideas. They're just terrible. And then you get into some of the referral firms where they're going to refer business to you. My experience with those is universally bad. Not everyone's experience is bad. Some people like them, and these are lead generation businesses. And so they'll have a website, a bankruptcy website. They're not bankruptcy attorneys, it's 100% marketing, but they'll have forms on there for people to fill out if they think they're in need or in trouble, and they'll answer certain questions, and then the form will generate a contact lead, which will show up in your email. And then you will follow up on that lead to try and get that business. And you usually are paying by the lead. So you're usually paying. But my experience with them is that you're having to sift those things in order to get the lead. And you're lucky if 1 out of 10 pans out. And then you have to argue with the company over, should I have to pay for the other 9 leads that just weren't panning out? I don't like.
They're not even bankruptcy related.
Yeah, they're not even bankruptcy related. Yeah, you get all kinds of stuff in there, and then you call people and they go, "I didn't call you. Why are you bothering me?" And I think there's a lot of there are a lot of false leads that come in for whatever reason, and I spend as much time with some of those things fighting them as I did trying to generate a lead. Lot easier to use other services. Can you think of any others that are kind of, just, I don't know, objectively terrible or dangerous for that matter?
I don't know. Dangerous.
Yeah, well, let's talk about being a feeder for debt settlement programs or things like that.
Oh, sure.
Yeah,
there are, because of this economic crisis that's imminent, right? So
Right.
we think, a lot of people think, and the future uptick in bankruptcies, I think, potential uptick in bankruptcies, because that's what everybody's predicting. I think
Right.
a lot of, there are going to be a lot of players who might not be quite legitimate entering the field trying to get people who are suffering to probably sign up for all kinds of programs.
right.
So some of them are going to be legitimate programs and some are not. So
Right.
it's difficult for a regular consumer to kind of, just kind of look through that and figure out what makes sense, what doesn't. And unfortunately, a lot of times, some of these companies don't have their best interest in mind, but also are really good at marketing and
Yeah,
making
they're
people
great.
sign up, and
Yeah,
make
they're
them feel
fantastic.
good and make promises
Right.
that cannot be, I don't know, fulfilled, because a lot of times we give people bad news in a way.
Yeah, well, I mean,
Yeah.
I would be aware, if you get contacted by somebody who provides those kinds of services, what they're looking for is boots on the ground. So they might be a national firm, but they need somebody with a Kansas ticket
Yep.
in order to legitimize
Their
their
operation,
operation, because they don't have a Kansas ticket. They're not supposed to be down here. And so they'll get people to sign up, and in theory, you're going to be their voice here, and you're going to appear for them. And if the client ends up needing a bankruptcy, you're going to file the bankruptcy. The problem is most of these things are debt settlement outfits, and they very rarely, in my experience, they very rarely conduct themselves properly. I don't believe that they give people all their options. I think they don't really explain Chapter 7 and Chapter 13 and the differences between that and either debt management or debt settlement. Debt management I send people to all the time. I'll send people to debt management. Debt settlement I have problems with. And part of it is the fees that the debtors get charged in debt settlement are extreme. It's not uncommon to see debt settlement fees be 25% of the total amount of the debt settled. So if a debtor comes in with a $40,000 credit card debt, the debt settlement company is going to try to settle that for, 40 or 50 cents on the dollar, but they're going to collect a 25% fee during this time, and the debtor is going to arguably pay $10,000 to get the same benefit that they could have gotten with a $2,000 Chapter 7 bankruptcy.
Well, sometimes.
Or a $4,000 or $5,000 Chapter 13, where they might have gotten a lot more benefit. My problem with it isn't just the fee that's being charged. My problem is that you have a duty to explain to people their options. And if you're not explaining them their options, that's a real issue. And I wouldn't want to be affiliated with one of those outfits because I think that people tend to get burned. And I think around 2008, we had a bunch of these outfits, a bunch of them that were out there. And the lawyers that were affiliated with them, I think kind of universally got in trouble. And I think there were some disciplinary administrator cases. So I would avoid that stuff. I mean, it just looks like a disaster to me. Mm-hmm. That's about it. That's probably the last thing I had.
Yeah. Yep.
Like any other area of law, it's a complex topic.
Sure.
We'll cover more later. Okay? We're done? I think so.
I think so.
Thank you. If you need to stop creditor calls, harassment, collections, lawsuits, repossessions, garnishments, or foreclosures, please give us a call. Consultations are free.